Next case on the docket is Life Care Centers of America versus Agency for Healthcare Administration. You may proceed whenever you're ready.
Good afternoon. May it please the Court. John Gilroy, representing Life Care Centers of America, the appellant. I'd like to reserve 5 minutes for rebuttal, please. And thank you for the opportunity to present this case. Very simply, ACCA's final order is wrong, and the agency action that precipitated the appeal, this appeal, is a gross abuse of discretion on ACCA's part. The case is rooted in the plain meaning of statutory language, and simply put, we believe ACCA just does not like the plain meaning of that statute. And we're asking this Court, number one, to confirm this administrative law judge's determination that patient days utilized by duly eligible nursing home residents qualify as Medicaid eligible. That was clearly found, and those should count towards meeting CON conditions as set out in the statute. We're asking the Court to confirm the ALJ's determination that ACCA's interpretation of statute is unreasonable. Contrary to plain meaning.
Let me tell you the one thing that caught my eye and I want you to respond to immediately.
Yes, sir.
ACCA in the brief talks about the reason for requiring people to take Medicaid eligible days is to encourage the people to take the lower recovery that they can get based on Medicaid when Medicaid alone is paying. My understanding is when you have the duly eligible patients, that in those situations the person is not being limited to the lower Medicaid rate. They're actually getting the Medicare rate. If that's what ACCA represents in the brief, and I think the record reflects that. So if we look at the purpose of this statute, I understand plain meaning in that, but if we look at the purpose of this statute, doesn't it get down to that being the purpose of the statute? To encourage people to take people for those lower paid Medicaid days?
Your Honor, it's really, first of all, duly eligible residents are, the agency in this answer brief seems to want to make it an either or. There's poor people and there's old people.
Okay, one thing I tell you, you saw that brief of, said, I'm here because of this. But one thing I tell my poor people is answer my question.
Sure. Yes, sir.
And I'm not sure you're doing that.
I'm sorry.
The question comes down to, isn't the purpose of the statute to encourage nursing homes to accept people for the lower paid Medicaid days?
It is.
And correct me if I'm wrong.
Sure.
The duly eligible people are not being limited to the Medicaid rate. They actually, the rates that are received for those days are the Medicare rate rather than the Medicaid rate.
For those patient days, that's true. The rate changes depending on the day. It's really not about the person as much as a particular patient day. And the purpose of the statute, we believe, as set out in the statute, is to provide access to Medicaid eligible residents, to make sure, to ensure access. And that was key, Judge, in the policy position that the only sort of policy point that was made by ACCA and that is relied on by them in the brief is that the statement about we need to make every effort to ensure that Medicaid patients have access to services.
But isn't it more than that? The Agency for Healthcare Administration is charged with administering the Medicaid program, is it not?
Yes.
And is ACCA charged with administering the Medicare program?
No, it's a federal program. I mean, it's shared, but it's a federal program.
But ACCA doesn't administer the funding through the states for Medicare, correct?
No, that's true.
So isn't it reasonable for the agency to place a condition on a certificate of need application that the recipient of the CON provide Medicaid patient days as opposed to Medicare days, since its mission is to provide for the Medicaid program?
Yes, ma'am. At the same time, The policy position that ACCA is taking does not, and the judge clearly found that there was, first of all, no evidence of an access issue. And the point made by ACCA as supporting policy for overriding the judge's interpretation was that somehow, if everyone was allowed to do what Life Care is doing, that would curtail access for Medicaid residents. And there's no factual connection there. To the extent that, yes, sir, on a given patient day, the reimbursement might be higher if a Medicaid resident, for example, as was found in the record, if a Medicaid resident at the nursing home, long-term care resident, goes to the hospital, has a stroke, breaks a hip, whatever reason, goes to the hospital for the minimum 3-day stay as required by Medicare, when they come back, there's a certain period of time when part of their reimbursement to the nursing home will be funded by Medicare. That doesn't make that person, and it doesn't change what their facility's relationship with that resident. They were a Medicaid resident to begin with. They still are Medicaid eligible when they come back. If the facility, because the services being provided are also higher when that person comes back from the hospital, they've got higher medical needs. So Medicare has said, we will supplement. But that same Medicaid eligible person it's the same person. And we're talking about, the statute does talk about patient days. And the language of the statute in referencing those patient days, it's that same person is both poor and old, put it that way.
And certainly that's a plausible explanation, but wasn't the ALJ required to find that the agency's interpretation was clearly erroneous? And under these facts, was ACCA's application of the statute to cover only Medicaid paid days an unreasonable application of the law?
He did find that, yes. And we absolutely believe that that's the case. And we believe it's ACCA's burden to then turn around and say, in essence, why his conclusion is why, number one, that they have a overriding policy consideration. And I understand, generally speaking, that they say we need to implement this statute, and yes, we have a general policy authority over this area. And it's very tempting to say, well, wait a minute, you've got poor people, those are the Medicaid folks, and that's what ACCA wants you to how they want you to see it, is Life Care is sort of disfavoring poor people and shunning and saying we don't want poor Medicaid residents in our facilities, and there's absolutely no record evidence of that. Even the chart that's set out in the recommended order shows that every one of those Life Care facilities provides an enormous amount of actual Medicaid with no...
Well, that's required under the certificate of need, right? I mean, you agreed to provide a minimum of Medicaid patient days.
Yes, sir. And in fact...
In this case... Well, go ahead, I'm sorry.
No, that's exactly the point. ACCA said, well, wait a minute. The statement of intent, as the statute says, we can condition a CON on your statements of intent. And that's fine. And they brought in those excerpts from those applications and said, see right there, Judge, to the administrative law judge, they said they do Medicaid. The judge examined every one of those, and number one, found that there was no clear intent as to Medicaid eligible versus duly eligible. And if I may, this statute, 0401B, the language at issue, didn't come into being until 1998. Most of these CONs were from the 80s in any case. And so likely there was just no real consideration of that. But in any case, ACCA doesn't have particular purview over contract issues. The judge found, as a matter of fact, there's nothing in these contracts. So we looked to the language of the statute.
Okay, well, let's go to the language of the statute. You're within 5 minutes. It seems the key words here are eligible and utilized Medicaid.
Yes, sir.
And I think your argument is that clearly these people are eligible for Medicaid because they are Medicaid patients, and so they're eligible. I know.
Medicaid eligible, yes, sir. And that was
Now, the
found
question
correct.
that ACA gets on is utilized, and they say it's only co-insurance and those kinds of things that are being utilized, that the Medicaid, it doesn't go for the actual services. Can you respond to that argument?
Yes, sir. I would love to. The argument being made by ACA is that somehow that word utilized is infused with policy. And if you compare paren B, 1B, to 1D, you'll see that the exact same sentence is there, except that in 1D they just use the word used. The only difference in that language is that the legislature uses the word used, utilized. Their argument is, what this means is that the Medicaid program was utilized, and not only that, but that it was the sole source of reimbursement. That's their case. They would replace this language with language that said percentage of annual patient days at the facility utilized by patients whose sole source of reimbursement or payment is Medicaid. And we would contend that the legislature could easily say that if they wanted to. May I reserve? I've got 4 minutes.
Yeah, I want to ask one more question. If I need to give you more time, I will.
Thank you.
The money that's being used, it says that Medicaid pays the deductible. Where does that money go to? Does that go to the Medicare program, or does that go to you, the deductible amount? So Medicaid can be utilized toward the deductible.
Right. It would be split, as I understand it, if you've got a per-day rate. Medicare, typically, for some of those days, I don't want to be expert on this, but it's like maybe an 80-20 split for a certain number of days.
Right.
The Medicare reimbursement is on a graduated scale over a limited number of days, not to exceed 100 for a resident in a year. So they come back from the hospital, they may split 80-20, and the Medicaid, it still goes to the facility.
To the facility.
Yes.
So, okay. So and I'm making your argument, and I want them to respond. So your Medicaid is being utilized for some care.
Yes, sir, at least in part. And the judge clearly found, so ACA's case is not only that Medicaid has to be utilized, but solely utilized.
Okay, you're down to 3 minutes, and if you need more time, I may.
Thank you.
May it please the Court, my name is Tracy Cooper, and I represent the Agency for Healthcare Administration. Judge, let me answer your question, and it's going to require a little bit of backing up here, but maybe I didn't explain it really well in my brief. This isn't just poor versus old, and it's just not Medicaid paid versus not Medicaid paid. There's a fundamental difference between the Medicaid and the Medicare patients we're talking about here, and by Medicare patients, I mean the dual eligibles. Medicaid paid patients are long-term care patients who are in nursing homes for many, many years. It can be somebody who's 80 and goes in with Alzheimer's and may be there until they die. Whereas these dual eligibles are usually short-term rehab patients. Now, some of them are also people who are originally in the facility and they're coming back, but some of them aren't. Some of these are just people who are going to come in for a little while, and because Medicare pays at a higher rate, generally, it benefits the nursing home to try to take these patients over the Medicaid long-term care patients who are the Medicaid long-term care patients who are paid for at the Medicaid rate. Now, Medicaid does pay at a lower rate, and so nursing homes do lose revenue when they take these Medicaid long-term care patients. And that's why the CON program offers this incentive to nursing homes to take these patients by, if you agree to do this, ACA is going to be more likely to grant your CON application. And that's what we did here. Now, our arguments here in this case aren't just based on the statutory language, it's on the actual CONs. If you look at the CON applications that were submitted by LifeCare here, there's no indication that they ever expected dual eligibles to count towards their Medicaid satisfaction. If you look at the application, there's no mention of dual eligibles, there's no attribution of Medicare revenues to Medicaid CON conditions, And the percentages in Schedule 7 that Life Care Expected shows that Life Care Expected Medicaid would be the payer of 100% of its Medicaid claims, of its Medicaid CON condition. So how can they now claim, and again, in their compliance report also, they actually asked us to consider dual eligibles. That means they knew we weren't going to consider them. So how can they now say that that's what they meant all along?
Well, I think the opposing counsel's point was the statute in reference didn't come into play until 98, and thus the CON might be silent or ambiguous as to that point.
I don't think if you actually look at the applications, which is what we're allowed to base the CON condition on, we can only impose a condition that is proposed to us. So if you actually look at the applications and you look at the numbers, they can't possibly have meant dual eligible patients.
What about the statutory argument that he's raised?
Well, there's a couple things going on with that. I agree that the statute could be more clear. I think that our interpretation is understood by all the nursing homes, and that, it's pretty well it's kind of hard to have 377 nursing homes with a CON condition like this one and suddenly let them all start counting dual eligibles. Right now we have enough room for all these Medicaid patients, but if you do that, it's going to be a problem.
Okay, aren't you, in your statutory argument, aren't you inserting the word solely before the words utilized and solely eligible? I mean, isn't that basically what the argument is? Because, it doesn't say that.
No, it doesn't say that. What you're not taking into account when you look at that, though, is there's a Section 1A and a Section 1B. And we can grant a CON condition based on anything that they submit. So if they submit something that says Medicaid only, then it's under 1B. If they were to submit something that says dual eligible, which I think they could, I think they could say dual eligibles could count, then that's under 1A. And here we're just talking about this other subset. And nobody at the time of inception understood this to include dual eligibles. Not only that, there's really no reason for a written opinion here because...
Tell me here, because you made another argument at the beginning that I probably didn't pick up on your brief real well. This is that long-term versus the short-term.
It's probably because I didn't understand it as well either. When you prepare for moot court, you go through things, and I think I said it, but I didn't say it the best way possible. So I wanted you to understand how it really is.
No, I understand that, but everything that agencies do have to have somewhere in the statute, authority. And I see the argument about, the Medicaid, that the Medicaid, we want the Medicaid patients taken care of. Mm-hmm. Where in the statute does it let you differentiate between the long-term versus the short-term people? Where's the authority for doing that?
The authority is that we can grant a CON application that, with the condition that says whatever the application says it should say. And we interpret utilized to mean, and eligible to mean only Medicaid paid patients. And it's very clear that the application also says that, so they agree.
But can you require stuff in an application that you don't have statutory authority for?
We didn't require this in an application. They submitted it voluntarily.
But isn't that a consideration? I mean, they didn't say we're going to take Medicaid patients because that's wonderful and fun and dandy. They did it for a reason.
Yeah, they did it for a reason. They did it to beat out possibly 150 other CON applicants. We wouldn't have accepted this application. We wouldn't have granted their CON if dual eligibles had been counted because there were other people.
But that's what I'm asking. The consideration of somebody being, that's obviously a matter you consider in whether to grant the application.
Yes.
Now, matters that you consider, don't you have to have some statutory authority for what you consider in whether to grant or deny an application or which person gets the CON?
Yes, Your Honor, but I think that, and I don't want to sound, but if you focus too closely on the statute, you kind of miss the point. And the point is that under 1A or 1B, we can grant a CON condition based on anything that's in the application. So you really have to look at the application. 1B is specifically Medicaid, but we could still do it under 1A.
But can OPTA say, okay, all of a sudden, well, we only want to protect those patients that are going to be in for longer than 30 days. We are going to consider how much community service work that they do.
We can't do that, Your Honor, and let me back up.
Okay, but that goes back to you. Why can't you do that?
If you look at section 408-035.
Excuse me.
I'm sorry.
Another thing I tell my court people is don't talk over the judge.
I'm sorry, sir. I didn't realize you were still talking.
Okay.
I got excited.
Authority. The reason you can't consider the charitable work that they're going to do is there's no statutory authority for doing that, right?
Right.
Okay, so my question goes down to everything seems to me that matters that you consider there has to be some statutory authority for. What is the statutory authority for considering long-term Medicaid patients versus short-term? I understand the policy reasons for doing it, and there might be some very good policy reasons, but is there anything in the statute that justifies that?
I think if you read 408-0401B along with 408-035, which is subsection 9, which says applicants past and proposed provision of health care to Medicaid patients and the medically indigent should be considered. The thing is that these Medicare dual-eligible patients aren't necessarily medically indigent. Sometimes they are, but not always.
How do they qualify for Medicaid as well, then? I'm just curious about that.
Well, what happens is when you come out of a hospital and you need a short-term rehab stay, Medicare will pay for your services for however long your rehabilitation period is, to a certain extent. For the first 20 days, they'll pay 100%.
And once that ends,
Medicaid will pay the coinsurance and the deductibles and things like that. We never, ever pay the costs of care. We pay for the things that Medicare won't pay for that are kind of incidentals.
But if they're eligible for Medicaid to cover those costs, such as deductibles and coinsurance.
It's a different program.
If for Medicaid to do that, then they must be somewhat indigent, right? A person with too many assets would not qualify for that Medicaid benefit, right?
I am not an expert in Medicaid eligibility. However, I will tell you that the QMB program is very different. There are different rules for how you qualify. And just because you're eligible for regular Medicaid doesn't mean you would qualify for Medicaid QMB. And just because you're eligible for QMB does not at all mean you'd qualify for regular Medicaid. So it's kind of like comparing apples and oranges. One final thing I'd like to remind you of here is that Life Care's already gotten pretty much everything that they wanted in this case. The fines that were imposed against them are the fines that were suggested by the ALJ at the reduced rate based on the dual eligibility inclusion. So they've already gotten the lowest fines that they can get.
Yeah, but their consideration is the same consideration you are. You don't want us to hold that dual eligible people would satisfy the requirement for Medicaid patients.
No, we don't.
And they want the opposite. I mean, well, the fines down, they want to be able to qualify these people.
Well, Your Honor, all I can say to that is there's 42,700 Medicaid beneficiaries in nursing homes under the long-term care program on any given day. And this opinion would affect all of those. Because if you were to accept these dual eligibles, then some of them would get booted out of their places. We wouldn't necessarily have enough space for them. Maybe not today, but if you look at the way the CON program works, people are allowed to request modifications and basically decreases in their conditions. And the time when we aren't going to be able to have enough space will come much sooner. So
the statute was amended to include dual eligible, right? The statute was amended in 2007. Doesn't it now make a reference to dual eligible?
I don't know, Your Honor. I don't believe so. There was an attempt to make some changes in a rule, but they didn't necessarily affect the dual eligibility. It was more the calculation. And if you don't have any further questions, I'll be happy to rest on my brief.
Thank you.
Thank you.
Okay, before everybody leaves, there's some glasses up there on the...
Oh, yeah, thank you.
Are those yours? Okay, Jim, wait, leave them. Go ahead.
Appreciate that. Judge, if I may, in sort of reverse order, in quotes, maybe not today, okay? That is exactly the theme. If you read through the agency's final order, and to the extent that they rested on a few straws from the recommended order where there was one statement made about things that might happen in the future, simply suggesting the statute can be amended. Judge Thomas, as of 2006, 2007, there was a change in this section, and the word duly eligible was included in 1D. Okay, it didn't directly affect this provision per se, but if you do read the current statute, compare 1B to 1D, to the extent that at one point ACCA was acting as if they didn't even know what duly eligible persons were, we pointed them to 1D. The current 1D actually says duly eligible. The legislature absolutely understands what that means. This is not a dichotomy between poor people and old people, or poor people and rich people, or short-term and long-term. The administrative law judge considered, with all due respect, considered all of that.
Is there a difference in eligibility for, quote-unquote, the duly eligible people versus just pure Medicaid patients?
No, sir. Paragraph 17 from the recommended order, Judge Stampello says, stated otherwise, Medicaid-eligible nursing home patients do not lose their status as Medicaid-eligible patients when the nursing home is reimbursed in whole or in part by Medicare, period. And all the discussion about how confusing Medicaid can be and Quimby and this part of the program, I mean, I'm sorry. Again, with all due respect, the agency had an opportunity to try to elucidate the judge about that at the time. None of that added up to anything other than paragraph 17. And simply put, some of these patients may be short. Every patient day provided to a duly eligible resident is being provided to a Medicaid-eligible person per the statute, period. There's no dispute about that. In addition to just substantively, if I may, we asked for fees. And the other part of this whole case has been, we've spent 3 years basically trying to, in my view, sort of chase down ACCA, pin them down, just to get this issue before you all. If you look at the track record of how ACCA came to the judge in a motion just before this hearing and said, we're not relying on this statement. We are explicitly, they said twice, explicitly will not rely on this statement. And in the final order, that's exactly what they do.
Okay, I'm going to give you 30 seconds to wrap up.
Thank you. That essentially is, Judge, but I just think it is critical to note, we think we've made a case about the statutory language, plain meaning of that statute. I mean, policy considerations don't rise to the level, and there's no evidence to support the agency's claim of an overriding policy consideration that makes any sense. But in addition, they have played hide and seek with this policy for 2 years worth of litigation, and we asked the court to recognize that and grant fees.
Okay,
Thank you, sir.